So it's the greatest of pleasures to introduce our final keynote, Baroness Brenda Hale, a trailblazer of the legal world that frankly needs no introduction, which makes my job here a little redundant. But as you will know, she's the first woman justice of the UK Supreme Court and the first woman to preside over the UK Supreme Court. Born in Yorkshire, before reading law at Girton College, Cambridge. For many years, she taught at Manchester, specializing in family and social welfare law, during which she was a joint founding editor of the Journal of Social Welfare and Family Law and authored a number of books. In 1984, she became the first woman to serve on the Law Commission, where she pioneered work which resulted in the Children Act 1989 and the Mental Capacity Act 2005. She was appointed a judge of the Family Division in 1994, the first to have made her career as an academic and public servant rather than a practicing barrister. In 1999, she was the second woman to be promoted to the Court of Appeal, and in 2004, the first woman law lord in the House of Lords. In 2009, the House of Lords was transformed into the UK Supreme Court, and she was one of its first justices. Became its deputy president in 2013 and president in 2017. Perhaps most famously presiding over the case in which the Supreme Court held that the 2019 prorogation of Parliament was unlawful. She's continued to retain links with academia and is currently a York Distinguished Fellow here at the Faculty of Law. We are delighted to have her here today and to hear her paper, The Fate of the UK Human Rights Act.
Thank you very much, Kirsty. I feel a real fraud being here, faced with so many real experts in European human rights law. What on earth am I going to talk about? Well, I was inspired by your theme of prospects, possibilities, fears, and limitations. And I thought I'd focus on the fears we all had last year for the fate of the UK Human Rights Act. And so I do what has become fashionable amongst legal historians and set those fears in the context of the history of the Act. Familiar to you all, no doubt, but perhaps just worth reminding ourselves of. We tend to forget just how recent the international human rights law project of giving rights to individuals is. As Kirsty has said, I read my law here in Cambridge. She didn't say from 1963 to 1966, that was kind of her. And in our first year, we had an introduction to public international law. It was all about the law of war and the law of the sea. I do not remember a single reference to international human rights law. It was solely concerned with the relationship between states, so I gave it up as soon as I could. Now, the omission is not surprising. We all know the modern international human rights law project was kicked off by the Charter of the United Nations in 1945. The preamble declares that the people of the United Nations are determined to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, and in the equal rights of men and women and of nations large and small. Note the nations. Among the purposes of the UN, listed in Article 1 is to achieve international cooperation in promoting and encouraging respect for human rights and for fundamental freedoms for all, without distinction as to race, sex, language, or religion. Note the emphasis on international cooperation, which chimes with the UN's emphasis on the sovereignty of the nation state. So we're not talking about rights for individuals here. Well, we are, but only in the context of the relations between states. Then along comes the Universal Declaration in 1948, with its ringing declaration that all human beings are born free and equal in dignity and rights, and its ambitious list of rights, which has formed the basis of many later human rights instruments, both in international and in national law. But that was just a declaration and didn't result in binding human rights instruments until my graduation year in 1966. So it may have been a project, but it wasn't a very effective project at that stage. In the meantime, the Council of Europe, and let's remember that the Council of Europe in 1950 was only the 12 democracies in Western Europe and Turkey. They decided to go it alone and produce the European Convention. The preamble reaffirmed their profound belief in those fundamental freedoms which are the foundations of justice and peace in the world, and are best maintained, on the one hand, by an effective political democracy, and on the other, by a common understanding and observance of the human rights on which they depend. Well, this is debatable. Conor Gearty, and he and I have been looking for the reference from which I got this. We'll find it. It's all right. I know I've read it. Because, of course, he argued that there's an inherent tension between the Human Rights Project and political democracy. Democracy, in his view, means that the will of the majority, as expressed through their democratically elected representatives, must prevail. The Human Rights Project means that there are certain rights which are protected against violation, even if the majority wills it. Well, we're still with that tension now, aren't we? Well, the convention set up the European Courts of Human Rights and gave it jurisdiction, not only over complaints brought by one member state against another, but also, and this was pretty groundbreaking, over complaints brought by any person, non-governmental organization, or group of individuals claiming to be the victim of a violation. Despite its early enthusiasm for the convention, the UK didn't accept this jurisdiction until 1966. There we are. But it's a very important date now I come to think about it. Date I graduated from this university, date of the two international covenants, date we accepted the jurisdiction. Well. One of the earliest cases against the UK was brought by another member state. You will recall that Ireland complained, among other things, that the 5 techniques used by the British in interrogations in Northern Ireland violated Article 3, the prohibition of torture or inhuman or degrading treatment or punishment. And in 1978, the court held that the techniques did amount to inhuman or degrading treatment, but not to torture. The British judge dissented. We are familiar with this British judge dissenting. Save in respect, of course, he didn't dissent in respect to the violations that the UK had actually put their hands up to. Otherwise, I think he would have done. Anyway, he voiced his emphatic opinion that if a commendable zeal for the observance and implementation of the convention is allowed to drive out common sense, then the whole system will end by becoming discredited. And his particular concern was enlarging the terms of the convention so as to include concepts and notions that lie outside their just and normal scope. I think we've heard those words more recently, have we not? Or something like them. Yeah. Of course, the target then was, and still is, the notion, clearly established in Tyre and the United Kingdom, that the convention is a living instrument which must develop to keep pace with changing social attitudes and conditions. But it's odd that a Brit should have objected to that, because this is nothing new in UK constitutionalism. You will all know that as long ago as 1929, in Edwards and the Attorney General of Canada, the Judicial Committee of the Privy Council had held that the British North America Act of 1867 had, quote, planted in Canada a living tree capable of growth and expansion within its natural limits, end quote. And their lordships did not wish, quote, to cut down its provisions by a narrow and technical construction, but rather to give it a large and liberal interpretation, end quote. Hence, they decided that while the word persons might not have included women in 1867, by 1929 it did. Well-known example of dynamic interpretation. And it weren't alone. The same approach, exactly the same approach, was adopted in 1980 in Ministry of Home Affairs Bermuda against Fisher, where the Judicial Committee held that the word child in the Constitution of Bermuda included a child born to unmarried parents, although at that time it would not have done so if included in an ordinary Act of Parliament. They said a constitution was different. A constitution is a legal instrument giving rise, amongst other things, to individual rights capable of enforcement in a court of law. Respect must be paid to the language that has been used and to the traditions and usages which have given rise to that language. It's quite consistent with this and with the recognition that rules of interpretation may apply to take as a point of departure for the process of interpretation a recognition of the character and origin of the instrument, and to be guided by the principle of giving full recognition and effect to those fundamental rights and freedoms with a statement of which the Constitution commences. It's pretty strong language from judges who weren't noted for their radical views on much. But it was also, of course, these two decisions, a firm rejection of the American doctrine of originalism, that the text must be read either in accordance with the original intention of the drafters or in accordance with what the original readers would have understood it. There are two versions of originalism. So we shouldn't have been surprised or dismayed when the European Court of Human Rights adopted a similar approach. The drafters of the convention were, of course, influenced by the content of the Universal Declaration, but they were just as influenced by the fundamental freedoms which the British had fondly assumed to be their birthright, since at least the days of Sir Edward Coke in the 17th century and Sir William Blackstone in the 18th century. So it came as quite a shock when the United Kingdom soon began to lose cases in Strasbourg. They weren't expecting it. I just went through the first 5 volumes of the European Human Rights Report. So we've got Golder in February 1975, implying a right to go to court, even for prisoners, into the right to a fair trial in Article 6. Tyrer in April 1978, holding that judicially ordered corporal punishment of juveniles violated Article 3. Sunday Times in April 1979, holding that an injunction prohibiting publication of articles about the thalidomide scandal because of the risk of contempt of court violated Article 10. This prompted another dissent from the British judge. What a surprise. Yeah. Who argued that the aim in Article 10 of protecting the authority and independence of the judiciary had been added at British insistence because of our law of contempt of court that the Continentals knew nothing about, with the implication that he was the only one who knew anything about it, and so his view should have prevailed, but it didn't. Dudgeon, well, we all know about Dudgeon, don't we, in March 1980, holding that Northern Ireland's continued criminalisation of certain homosexual acts between adult men violated Article 8. My late lamented colleague Brian Kerr, who appeared for the government, I think as junior for the government, being led by Nicholas Brapser, no less, said that he was told by a Northern Irish politician to go and save Northern Ireland from buggery. Well, he knew he wasn't going to. They knew they were going to lose, but there we go. Young, in June 1989, holding that dismissal for refusing to join a trade union, a British rail trade union when they had a closed shop, violated Article 11, freedom of association, thus establishing that a right to do something in the convention includes the right not to do it. And some of you may remember that we were very pleased that that had been established when we were confronted with the Northern Irish gay case. So the bakers could not be obliged to publish a message with which they profoundly disagreed. Campbell and Cousins in February 1982. Did you realise there were so many so early? No. Holding that insisting on corporal punishment in schools violated the parents' rights under Article 2 of the First Protocol. Silver in March 1983, holding that censoring prisoners' letters to MPs and solicitors, but not to other people, violated Article 8. And Malone in February 1984, holding that the unregulated common law allowing the police to tap private phones violated Article 8. I could go on. And note that by no means all of these were the result of primary legislation about which the British courts could do nothing. Some of them stem from the common law, which might perhaps have been developed to meet the situation. Well, on the whole, British judges are not that courageous, but there we go. And added to these shock defeats were several friendly settlements reached after the Commission had found a violation and the government had decided it wasn't worth having a fight. But of course, they never admitted there had been a violation, they just paid up. Yeah. So it's not surprising, is it, that calls to incorporate the convention into UK law had begun even before the shocks. Anthony Lester argued for this in a Fabian tract, Democracy and Individual Rights, in 1968. Sir Leslie Scarman, the first chairman of the Law Commission, advocated it in his 1974 Hamlin Lectures, English Law, The New Dimension. In 1978, a House of Lords Select Committee voted in favour of a Bill of Rights by 6 to 5. I haven't looked up who the 6 were and who the 5 were. I better do that. Yep. Anyway. Between 1969 and 1997, there were no less than 11 bills introduced into the House of Lords, mostly by Lord Wade and Lord Leicester, 6 of which passed all their stages in the Lords and were sent to the House of Commons, where nothing happened. In 1987, a Conservative MP, Sir Edward Gardner, introduced a private member's bill in the House of Commons. And in 1996, the newly appointed Lord Chief Justice, Lord Bingham, used his maiden speech in the House of Lords to argue for incorporation. So there was an awful lot going on, and it became Labour Party policy. Jack Straw and Paul Bretting published a consultation paper in December 1996, bringing rights home, Labour's plans to incorporate the European Convention on Human Rights into UK law. The arguments were simple, and some of them still resonate today. Because their rights were not protected in the UK courts, British people had to undergo the lengthy and costly process of applying to Strasbourg. British judges were denied the opportunity of building a body of case law which was properly sensitive to British legal and constitutional traditions. The European Court of Human Rights hadn't been able to benefit from the experience of the UK legal system and was neither sufficiently familiar with or sensitive to British legal and constitutional traditions. Incorporation would reduce the degree of recourse to Strasbourg, and it was implicit, if not spelt out, that it would reduce the proportion of cases which we lost there, as indeed it has done, dramatically. I well remember, I was one of the privileged judges whose name came up in the ballot to sit on the woolsack at the Queen's speech in 1997. Imagine the excitement that there was on the woolsack when Her Majesty announced that a bill will be introduced to incorporate in United Kingdom law the main provisions of the European Convention on Human Rights. And so it was. There was the bill introduced in December, along with the white paper. And the white paper pointed out that it had been thought when we ratified the convention that the convention rights and freedoms were already protected in British law, as I said. But it turned out that they were not. The rights originally developed with major help from the UK government were no longer seen as British rights, which they actually were. Now, that's a point that still resonates today, doesn't it? They are still seen as filthy foreign rights rather than the British rights, which they all began as. UK judges had a high reputation internationally. They're always saying that. I have no idea what the evidence for that is. But they said the fact that they do not deal in the same concepts as the European Court of Human Rights limits the extent to which their judgments can be drawn upon and followed. With incorporation, we would be speaking the same language. The white paper did consider whether the court should be given power to strike down or ignore incompatible provisions in acts of the UK Parliament. After all, the European Communities Act had given them this power, so a Human Rights Act could do so too, unless and until it was repealed. Various compromise models were considered, in particular the one adopted in Canada when it decided to repatriate its constitution and adopt a Charter of Fundamental Rights. This would allow the Supreme Court of Canada to strike down inconsistent laws, but the Canadian Parliament was and is allowed to pass laws notwithstanding their incompatibility with the Charter rights. And those laws the court could not strike down. In practice, very little use has been made of the notwithstanding power, but it is a safety valve which enables the will of the elected to prevail. But the government decided not to adopt either the EU or the Canadian solution, pointing out that the EU solution was a requirement of EU membership, whereas there was no such requirement in the European Convention. So parliamentary sovereignty should prevail. The authority of Parliament to make decisions about important matters of public policy was derived from the democratic mandate of its members, who were elected, accountable, and representative. Allowing the courts to strike down acts of Parliament would be likely, on occasions, to draw the judges into serious conflict with Parliament. The judges did not want this, and the government had no mandate for such a change. Well, they were quite right that the judges did not want this. As far as I know, we still don't. But they were perhaps naive to think that politicians and the public could distinguish between a conflict with Parliament and a conflict with the government. So the Human Rights Act was passed and came into force in 2000 after a massive training programme for all the judges. And it took some time for the courts to get used to their new jurisdiction. Several puzzles. First, how did human rights adjudication differ from common law judicial review of administrative action? It took landmark decisions such as Ulla, Denby High School, and Misbehaving, my favourite, to establish that this was not judicial review. The courts had to ask themselves whether a convention right had been violated, while of course recognising that certain policy judgments were properly to be left to Parliament or government. Second conundrum, how far did the new duty to read and give effect to legislation, so far as possible, in a way which was compatible with the convention rights go? The limits were established early on in Re-S, Children, Care Order, Implementation of Care Plan, where the Court of Appeal on which I sat was firmly squashed by the House of Lords, which seemed to have forgotten the words give effect as well as read and give effect. We had tried to give effect, but we were told, no, we had to have a provision which we could read, and we had to read this provision in a particular way. Well, I don't often think that the higher court that has overturned me is wrong, but I did think that they were wrong. So, however, the possibilities clearly emerged with Gaida and Godin Mendoza. Of course, the courts had learnt the techniques of compatibility interpretation from EU law. It soon emerged that the government preferred the courts to solve an incompatibility. I mean, they always used to say it's not incompatible, but their second line was always, if, contrary to what we think, you hold it is incompatible, please will you interpret your way out of it? Because they didn't want to be left with having a declaration of incompatibility, which then they would have to take the political flak for solving. But sometimes, of course, we had no choice but to make a declaration of incompatibility. I think one of the very early ones was the Belmarsh case, as you know. And by and large, the government's record of acting on declarations of incompatibility has been impressive, although sometimes they've done so through gritted teeth. Well, worse than that, when the Supreme Court declared that the inability ever to have one's name removed from the sex offenders register was incompatible with the right to respect for private life, the Prime Minister introduced a remedial order to provide some machinery for said removal, while questioning the sanity of our ruling and suggesting that we had forced him to do this. Well, of course, we didn't think we were insane, but we certainly hadn't forced him to do it. It's always up to government and Parliament to decide what, if anything, to do about a declaration of incompatibility. Although Sir Stephen Laws has argued that in practice they have to do something. Well, they don't always. They didn't with prisoners voting, if you recall. But that's the only real example of prolonged resistance to acting on a declaration of incompatibility. And they held out for so long that the Council of Europe eventually gave in and accepted that some minor administrative changes were enough to break the logjam. And the Prime Minister, the same Prime Minister who questioned our sanity, declared that the idea of prisoners voting made him feel physically sick. I have never understood why the right to decide the franchise should be unique to the people who benefit from the current franchise. The whole purpose of fundamental rights, including, one would have thought, universal suffrage, is to protect those rights, even if the majority and the majority elected don't like it, because they're the beneficiaries. So they shouldn't be in charge. I think it's a very good example of what the Human Rights Project is all about. Anyway, we're talking after 2010, aren't we? And criticism of both the Strasbourg and the UK courts began to mount. Certain sections of the media were, of course, upset that the courts were developing a tort of misuse of private information. The courts were public authorities. We had to act compatibly with the convention rights, even in cases between private persons. So we had to balance a newspaper's right to freedom of expression against an individual's right to respect for her private life. The Daily Mirror was not entitled to publish photographs and details of supermodel Naomi Campbell's treatment for drug addiction. But the newspapers had got used to being able to publish all sorts of private information, whether about celebrities or about ordinary people, and they didn't like their activities being restrained. And so they began to refer to the Hated Human Rights Act. Hated by whom? Well, certain sections of the media and certain sections of the politicians, not necessarily by, and the people who believe them. They weren't alone. The media weren't alone. In a lecture in 2011, Michael Howard, former leader of the Conservative Party, attacked the Strasbourg court for descending into the minutiae of the convention rights and denying member states their proper margin of appreciation to interpret and apply the convention in the light of local conditions. He also attacked the UK courts for going beyond Strasbourg case law in interpreting the convention. In another lecture that same month, actually, these are both prestigious lectures. The Howard one was the Kingsland lecture for policy exchange, and the other was the next one was the FA Man lecture. Jonathan Sumption, QC, soon to be a justice of the Supreme Court of the United Kingdom, attacked the Strasbourg court for its detailed development of the general principles in the convention, for deciding not only whether the member states have proper institutional safeguards for those rights, but also whether it agreed with the findings of those institutions, and for attempting to apply the rights in a uniform manner throughout the 47 member states, despite the fact that the consensus necessary to support it at this level of detail does not exist. There are never any footnotes in Sumption lectures. I don't know if you've noticed this. And after retiring from the court, he expanded upon those views in his 2019 week lectures, although he was almost as critical of the politicians for not doing what he thought was their job as he was of the courts for doing what he thought wasn't their job. Yeah. So, fixing the Human Rights Act became a recurring theme of Conservative Party manifestos, although the proposals were subtly different each time. The 2010 manifesto announced that, quote, to protect our freedoms from state encroachment and encourage greater social responsibility, we will replace the Human Rights Act with a UK Bill of Rights, end quote. Does that make sense? Don't know what it meant. Yeah. But of course, from 2010 until 2015, the Conservatives were in coalition with the Liberal Democrats, so it didn't happen. Then in 2015, they promised to, quote, scrap the Human Rights Act and curtail the role of the European Court of Human Rights so that foreign criminals can be more easily deported from Britain, end quote. A more radical proposal, but for a more limited purpose. They didn't go on to say, so that fundamental rights and freedoms will have less protection in UK law than they have hitherto enjoyed. They didn't say that. Yeah. There we go. Maybe what they meant. Somewhat to their surprise, of course, they won the election. So active steps were taken within the Ministry of Justice, particularly while Dominic Raab was Minister for Human Rights from 2015 to 2016. In fact, that's when when last year's bill was actually drafted, as you can tell when you look at it. Yeah. But by 2017, not only had little progress been made on the project, but it had been overtaken by the all-consuming demands of Brexit. Thus, Theresa May's 2017 manifesto declared that we will not repeal or replace the Human Rights Act while the process of Brexit is underway, but we will consider our human rights legal framework when the process of leaving the European Union concludes. We will remain signatories to the European Convention on Human Rights for the duration of the next Parliament. Understandably, most of the 2019 manifesto was devoted to getting Brexit done. But the promise was to, quote, update the Human Rights Act and administrative law to ensure that there is a proper balance between the rights of individuals, our vital national security, and effective government. So the plan was to set up a Constitution, Democracy and Rights Commission in their first year. In fact, that didn't happen. Instead, the government first set up the Independent Review of Administrative Law under Lord Fawkes. This found very little wrong with administrative law, but recommended some small changes. If ever there was a case of low-hanging fruit, it was the recommendations of that review. The government then, of course, consulted on some much more radical changes, but retreated when these were widely condemned. And so the resulting act contained the small changes. Then the government set up the Independent Human Rights Act Review under Sir Peter Gross. whom nobody would accuse of being the most radical. Lovely man. And its remit was not to look at particular convention rights, but at the relationships between the UK courts and the Strasbourg court, and between various branches of government in the UK. It too concluded that nothing much was wrong. Meanwhile, the House of Commons and House of Lords Joint Committee on Human Rights produced a report on the government's independent review. This noted that the Human Rights Act had had a wide impact outside the courtroom, Whitehall and Westminster. The duty of public authorities to act compatibly with the Convention rights had embedded human rights amongst public authorities and reduced the need for litigation to enforce people's rights. Far from curtailing the scope of the Act, where rights did need enforcement in the courts, this should be accessible to all. So, among other things, the Equality and Human Rights Commission should be given the same powers to enforce human rights as it has to enforce equality rights. That's a good idea, isn't it? There we go. Then the government produced its own consultation paper, ignoring the careful work, or most of the careful work, of the Joint Committee and the independent review, and proposing to replace the Human Rights Act with a, quote, modern Bill of Rights. On the plus side, the government was still committed to remaining a party to the Convention, to retaining all the substantive rights protected under the Human Rights Act, and to fulfilling its international obligations. Two of these are, of course, vital. One is the obligation in Article 13 to provide an effective domestic remedy for everyone whose rights and freedoms set forth in the Convention are violated. The other is to retain the right of individuals to apply to the European Court of Human Rights and to abide by any final decision of that court. Many of those who responded to the government's consultation judged its proposals against these obligations and found them wanting. But the government went ahead and introduced the Bill of Rights Bill. The bill had its first reading in the House of Commons on the 22nd of June, 2022. But there was no enthusiasm for it after Dominic Raab resigned as Lord Chancellor in April this year, and it was formally withdrawn on the 23rd of June. But it is worth remembering its main features to remind us of some of the threats that it posed. First, it began with political sloganizing. I can't think of another bill, certainly before this one, which has started with completely unnecessary statements of the blindingly obvious which did not need to be in legislation. I'm really surprised that parliamentary drafts, they'd never have let us get away with it in the Law Commission. I'm really surprised that they seem to have let the government get away with it. So it is the Supreme Court and not the European Court of Human Rights that determines the meaning and effect of convention rights for the purpose of domestic law. Yes, of course, it was ever thus. The Supreme Court, and indeed any court which finally decides a case concerning the convention rights, already determines their meaning and effect in domestic law. Taking the case to Strasbourg is not an appeal from the decision of the domestic court. If the UK loses in Strasbourg, this decision still stands. Something has to be done about it, but the decision still stands. Even if Strasbourg finds that the UK has violated the convention rights, the interpretation arrived at by the UK court is still binding on the lower courts until the higher court, which reached that interpretation, says that they're going to depart from it or reverse it. These facts seem not to be well understood by certain people. Equally obvious are the statements that judgments, decisions, and interim measures of the European Court of Human Rights are not part of UK domestic law and do not affect the right of Parliament to legislate. Do we really need to be told that? Now, after that sloganizing came a series of provisions designed to uncouple the UK's interpretation and application of the convention rights from Strasbourg's. The duty to take into account Strasbourg and other Council of Europe jurisprudence was to be repealed. Well, at least they didn't forbid us from taking them into account. I suppose they might have done that. The duty to read and give effect to legislation compatibly with the convention rights was to be repealed. The courts were to be told that they should pay particular attention to the text of the convention and could look at the travaux préparatoires. Now, this is a nudge towards American originalism, which Strasbourg had rejected decades ago, as I mentioned. Actually, there's a nice little early example of this in the Commission. In the Commission report in Campbell and Cousins, the UK had argued that the travaux préparatoires had indicated that philosophical had been added to the religious opinions of parents who objected to corporal punishment to cater for agnostics. So it only meant agnostics. The Commission countered that philosophical clearly had a wider meaning than just agnostics, and it should be given that wider meaning. It's a really good example of not relying on the travaux. There we are. And then the bill said the courts could only develop the convention rights further than Strasbourg if they had no reasonable doubt that that was what Strasbourg would do with the case. No reasonable doubt. The Supreme Court did get it right in Rabone, which is a case that the government didn't like. But could we have had no reasonable doubt of this? I mean, we got it right, and very shortly after we decided Rabone, Strasbourg decided a case to the same effect. But could we have had no reasonable doubt? Not sure about that. And what good would the, again, completely unnecessary, express power to have regard to the development under the common law of any right which is similar to the convention right, if the common law had developed that right further than Strasbourg had done? What are we to do? We could have regard to the common law development, but we couldn't go further than Strasbourg unless we had no reasonable doubt that that's what Strasbourg would do. I'm so glad I'm not a judge anymore. And tellingly, of course, the one exception to this no expansion was freedom of expression. So we're back to the sloganizing, aren't we? And the one new right was a completely empty right to trial by jury. So wonderful to say. All it did was declare, you know, trial by jury is a means whereby UK law complies with the duty to have a fair trial. Now, there was no need to say that because Strasbourg had accepted that long and long ago. I mean, obviously, there was some doubt because juries don't give reasons, but they worked out a way of saying it's nevertheless a reasoned judgment because they've been listening to the judge. Sometimes. And then it said, but of course, you know, we leave it to the law to work out when you actually are entitled to trial by jury. Completely empty right. But more striking was the cutting down of the existing convention rights. There were to be no new positive obligations, even if Strasbourg devised them. That is defined as a duty on a public authority to do something. Worse still, the courts will be given a discretion whether or not to apply even those positive obligations already established. I mean, I find this quite astonishing. They would have to consider the burden placed on the public authority concerned before applying an existing interpretation. There will be people in this room who know that there are other provisions to similar effect, but I am not aware of a statutory provision which tells the courts they don't have to do what the law says they should do if it's going to make life difficult for public authorities. So the victims, I mean, a prime target would be the victims of the police failure to catch John Warboys, the black cap rapist, much earlier, which they could have done. But those later victims might be left without a remedy, because it's putting too much of a burden on the police. And of course, on top of that, people alleging breaches of their fundamental rights would have to get permission to bring a claim, when people alleging breaches of their ordinary rights don't. That seems very odd, doesn't it? So there we go. All in all, the bill was likely to mean that more claimants would be denied an effective remedy here for the breach of their convention rights. More would have to go to Strasbourg to vindicate their rights, and the UK would lose more cases in Strasbourg than it had been doing since the Human Rights Act came into force. So should we breathe a sigh of relief that the bill has been abandoned? I don't see a lot of relief in the room. I fear not. Once again, there are dire mutterings about withdrawing from the convention altogether if the government lose their appeal in the Rwanda case. The Home Secretary has made no secret of her desire to do so. And the vibe coming out of Number 10 is that she had Number 10's approval to float the idea. Perhaps Perhaps more realistically, the government has shown itself willing to procure legislation in the shape of the Illegal Migration Act, which will rule out certain human rights claims and require ministers to ignore them when making their decisions on the deportation and detention of people arriving here without the permission they need. It's very difficult to see how this complies with the obligation to provide an effective domestic remedy for breaches of the Convention of Rights. I don't know if any of you grappled with the illegal migration. I think the word illegal actually applies to acts rather than migration, but there we go. I don't know how many of you tried to grapple with it. I made a start and tried to grapple with it in preparation for today. It is an absolute nightmare of a piece of legislation to try and get your head round. But it'll be an even worse nightmare for the people who are affected by it. But it's part of a wider tendency to disregard the UK's obligations in international law. There are many other examples in that act and elsewhere. And perhaps we should add to this contempt for international law a willingness amongst some in government unjustly to pour scorn on lawyers and even judges who are only doing their job. I can't resist reminding you that on Monday, the 18th of July last year, the then Prime Minister moved the motion in the House of Commons that this House has confidence in Her Majesty's government. This is a very unusual motion for anybody to move. Detailing his government's achievements, he declared that, quote, "With grim determination, we saw off Brenda Hale and we got Brexit done." Neither the Speaker nor the Leader of the Opposition reacted. But this is a pretty jaw-dropping thing for a British Prime Minister to say. He was, of course, referring to the decision of the Supreme Court on the 24th of September 2019 that his advice to Her Majesty that Parliament should be prorogued was unlawful and of no effect. But he was, of course, wrong for at least 5 reasons. First, although it was Brenda Hale's job as president to announce the decision of the court, it was not her decision alone, but that of all the 11 justices who'd heard the case, in effect, the whole court. And our former Prime Minister does not know much about the court if he thinks that the president can get her fellow justices to sign up to anything with which they disagree. They are independent and strong-minded people. Second, neither I nor my fellow justices were trying to stop Brexit. That was not what the case was about. It was about the Prime Minister's attempt to prevent Parliament from performing its proper constitutional role in the Brexit process. But however often we say that, some politicians refuse to believe that we were standing up for Parliament, not frustrating Brexit. Third, the Prime Minister implied that he had ignored our decision, which he did not and could not do. Parliament reassembled the very next day and went about its troublesome business. The very suggestion that the government might ignore judicial decisions, which it doesn't like, is extraordinary. Yet there have been examples recently of ministers refusing to obey court orders, and Dominic Raab had floated the idea of legislating to give them just such a power. Fourth, the Prime Minister may even have implied that he was responsible for my departure from the Supreme Court in January 2000, which of course he was not. I retired at the beginning of the law term in which I would reach the mandatory retirement age of 75. And the mere suggestion that the Prime Minister can remove a judge from office is the most shocking of all. Since the Act of Settlement of 1701, all senior judges hold office quam diu se bene gesserit, so long as she shall well behave herself therein. I was sworn into that effect in 2004, and it created the same mirth amongst the members of the House of Lords. And indeed, my Canadian friend visiting to watch the proceedings was surprised that I had to promise to behave myself, or I would only hold office for so long as I behaved myself, whereas the ordinary peer who was sworn in at the same time didn't. But actually, it's a safeguard of judicial independence and a very important one. And finally, what he said was a bit rude, wasn't it? But I do have some sympathy for that, because I'd unwittingly been a bit rude to him when I wore a sparkly spider brooch while announcing the prorogation decision. If only someone had told me that The Who had recorded a song called Boris the Spider, in which Boris the Spider comes to a distinctly sticky end, I wouldn't have worn that brooch. You can see it on YouTube. So after all of that, to return to Conor Gearty, some years ago, he posited the scenario of an extreme left-wing government doing all sorts of terrible things, and a right-wing nationalist government, which, quote, goes after immigrants and asylum seekers in a dramatically aggressive way, end quote. Under the British model, the law would be able to do next to nothing in reply. But Gearty believed that the culture of human rights, rooted in legal practice, but also in society's common sense of basic standards, serves to support the ethical status quo against such plunges into extremism. That's sounding awfully optimistic, isn't it, these days? We can but hope that he will eventually be proved right. Thank you.